welcome the dignitaries, Honorable Judge, Supreme Court of India, Mr. Justice P.S. Narasimha, Honorable Judge, Delhi High Court, Mr. Justice Sanjeev Sachdeva, Mediator and Trainer, Mr. Braj Bihari, Honorary Secretary, Delhi High Court Bar Association, Sandeep Sharma, and the Organizing Secretary, Samadhan, will also be on the stage, Veena Aralichi. We welcome all of you in this valedictory session, ladies and gentlemen. At the outset of this session, I invite Honorary Secretary of Delhi High Court Bar Association, Mr. Sandeep Sharma, for his felicitation address, his welcome address. Sandeep Sharma ji, please.
Good evening to all the honorable judges, esteemed guests, and fellow colleagues. We have come to an end of a memorable two-day conference on behalf of all the members of the Delhi High Court Bar Association. Before you, with a deep sense of privilege, would like to take this opportunity to extend my respect and regard to all those who have been directly and indirectly involved with this, towards the success of this conference on mediation at the dawn of a golden age, which has been organized by Delhi High Court Mediation and Conciliation Center, also popularly known as Samadhan. At the outset, I convey my deepest regards and thanks to all the honorable judges of the Honorable Supreme Court, the judges of Delhi High Court, the judges of all other high courts, and my members of Samadhan. I would also like to take this opportunity to extend gratitude to the organizing committee and staff of Delhi High Court, who for their unflinching support and coordination, as without their backing it would not have been possible to organize this conference at such a grand level. As my president has already said, that Delhi High Court Bar Association will provide each and every support to any constructive step which is taken by Samadhan and the Mediation Center. Today, mediation is one of the most effective and well-known alternative dispute resolution methods, which helps the litigants to resolve their dispute voluntarily and amicably with the assistance of an independent third party known as mediator. I was just hearing Justice Khanna referring to that arbitration clause where now most of the contracts are provided for mediation. My experience is that in those clauses, the mediation has not been very effective, though we have tried everywhere, because that is the process before we go into arbitration. So that is one area where I think we really need to work, because at that stage, parties are directly involved with each other on settling the disputes. Mediation has been building new faith, new bridges of faith between the litigants, and such acceptance of mediation by litigants as an appropriate dispute resolution process is evident from the fact that more than 100 matters are listed before the mediators at Samadhan on each working day. And a large number of disputes have been resolved, as was being pointed out. Reference has also been made to Section 89 of Code of Civil Procedure and also to the Commercial Courts Act, which has really helped the mediation between the parties. According to me, further attempts and awareness should be made to promote mediation by making it a mandatory step. Though just before this, Mr. Xavier was saying that it shouldn't be mandatory. Like Justice Sikri said, that we have to just take parties to the mediation, and then whether it is settled or not, that is an attempt which is to be made. Moving further, I thank everyone for their involvement they have shown and the willingness that they've expressed to take on the successful completion of tasks beyond their comfort zones. With these warm words and a kind message, we move to the end of today's conference, thanking you all. Thank you.
Thank you. Thank you so much, Sandeep ji. Ladies and gentlemen, as you know, Mr. Braj Bihari Das, an advocate in USA and internationally renowned, a known mediator and mediation trainer. He is actively involved with the ISKCON, Sankalp, and doing great service to the sect and the society. I will request Honorable Mr. Braj Bihari ji for his sharing his thoughts and address the gathering.
So I was told that, and I was speaking earlier, that I spoke very succinctly, very briefly. So now I have a PowerPoint and it goes on for 2 hours. So I was thinking of what to say for this final talk, and I was in the this last week I was in the state of Washington near Seattle for my work with the Department of the Interior, and I was visiting various Indian reservations. This is the Colville Reservation. It's over 1.3 million acres of land in not too far from Seattle. Matter of fact, I think that's how I got this job 12 years ago. They looked at my resume and they read it too quickly. They saw 21 years India and they thought it was Indian. And they said, "You have so much experience. Well, you're hired." But anyway, I do a lot of work with Native Americans, American Indians. And so I was trying to get some inspiration about what I would say for this last few minutes. It's a few minutes, not 2 hours. And I went to this one office on the reservation, and I saw this picture. I hope you can read. Maybe you can or cannot read the the bottom there. I better put on my glasses to read it myself. But it says, "We respect the community of our elders, past and present, and pay attention to their good words." I thought that was really beautiful. I mean, it's very much our Indian culture, our Vedic culture, and it's also a very important part of the Native American culture. And I thought that, yes, that was the inspiration for this short talk. And I was thinking about the early days of trying to introduce mediation into in India, and the great fortune that I had to work with some very special people. I just want to highlight 4 of them. I know there's many, many others, and my apologies for not naming everyone, but these are 4 people that have given me great inspiration by their, I'll talk a little bit about them. First of all, Naranjan Bhatt. Naranjan, now he must be 87, 88 years old. He's just a ball of energy and enthusiasm. I think of him like as Hanumanji. He's just like full of, he was just so convinced about the importance of mediation and how much it would help this country to introduce mediation throughout the court system. And just isn't it, Sadhana? And Sri Ram, he was just so enthusiastic and a great pioneer, And then, of course, we have our Sri Ram, Anshu, and he's like the Vyasadeva of mediation. He's written, he's the philosopher. He's established the what we might say in spiritual terms is like the siddhanta for mediation, just the pure approach to how to introduce this modern mediation into a country. And he's wrote this this amazing book, Settle for More, and then others. That book especially is popular and should be like required reading for all 10+2 students. And Sri Ram, again, just such an inspiration over the years to work with him. And then we have Sadhana, and her. I'm going to mention her and 2 others in one group: Sadhana and JP, and Mr. Chanjok. And these 3, I think I would compare them to Vishvakarma. He was the architect of so many of the great structures in Vedic times, and they did many things for mediation, but they created this container, for example, Samadhan, and just they used their expertise. They knew how to, as we would say, move the material energy in such a way to create a container for mediation to take place in India. And these 4 people have given me so much of their kindness and so much of their, and I've been so inspired by them because, especially in those early days, it was so clear. It was very inspiring for me to just see the purity of their intention They weren't getting any money out of it, for sure. And they weren't getting even any prestige out of it. It was just, they saw that this is something that is necessary for the country, necessary for the individuals who can benefit by being in a mediation, and they just worked selflessly towards that goal. And that's for me. I've tried unsuccessfully. I have tried for the last 46 years to try to be a person with pure intention in my spiritual pursuits. I say not so successful, not like them in their pursuits for helping the country, but it's inspired me. And I've for the last 46 years, I've been a student of the Bhagavad Gita, and I was. I have a picture of. I found this the other day. A picture of me when I was a monk. I was 19 years old. I didn't know how to wear a dhoti very good there. And I think my shoelaces are untied, so I wasn't a very pukka monk, but I was a monk nonetheless. And I did that for 12 years until I met my wife, my future wife, and that was the end of being a monk. People sometimes ask me, how does a monk meet their future wife? That's a story for another time. Yeah, we won't go into that. But I would like to end by, again, seeing the enthusiasm and the purity of these four people and their intentions. It reminded me very much, and I had to think about what are my values in being a mediator. And I went to the Bhagavad Gita for that, and tried to, make a summary of what would be Gita values as applied to mediation. And I hope you see these not as just religious, but as universal in their application. So the first one, ahimsa, which I'm sure you're all familiar with, it's mentioned 9 times in the Bhagavad Gita, that word, and do no harm, nonviolence, and isn't that one of our mantras? And we even say that. I think that the Chief Justice of Singapore was saying 70%, wasn't he saying that the settlement rate? But we say even the other 30%, 28% of that, there's some progress, some benefit. As we heard when Justice Sikri was talking about Sri Ram Anshu and the Ram Jamabhoomi situation. Priti, or acting with kindness. And we heard the Chief Justice of India yesterday say that the government must be a friend. So we're not kind to one party and unkind to the other, but that mood of seva and compassion is part, at least for me, of trying to be a good mediator. And then icha, and this is can sometimes mean desire in Sanskrit, but it can also be translated as choice. And isn't that, I think all of us in this room can relate to that one, right? That we try, that we, it's not us to tell the parties what should be the settlement. We facilitate them coming up with a settlement. And I'm sure all of us who have mediated, sometimes we think, oh my God, did they choose that one? Right? And then we're stuck with the dilemma whether we should bring it up or not, but we do honor that they have that choice. They have choice. And then amannitva, humility. And our Chief Justice of India, he mentioned the Ted Lasso. He stole my thunder. He stole that story. But in the Ted Lasso episode, if you've ever seen the TV show, he says that he saw a billboard that says, "Be curious, not judgmental." And for me, that's something I tried to apply in my life, not prejudge people, not make assumptions about people. I would say the number one cause of conflict, this is when I do trainings, I say the number one cause of conflict in the world is when we make assumptions about others that turn out to be incorrect. And I find the number 2 cause, and this might be very much in matrimonial situations, is unclear expectations. Anyway, the whole idea of appreciating other people's perspectives and knowing that we don't know everything. And the older I get and the more I learn, the more I realize how little I know. And I think it's such a attractive feature for us as mediators to approach the profession and the parties and one another with that sense of humility, that sense of curiosity, as we heard from the Chief Justice the other day. And then Acharya, teaching by example. You know, that saying, what you are speaks so loudly I can't hear what you're saying. And I mentioned that earlier, that when we are sattvic, when we're cool, calm, and collect, the parties pick that up. And I quoted that sattva sanjayate jnanam, that they cool down, and they often, I've found, can start saying things a little bit more clear just by picking up that mood from us. So teaching by example. And then finally, samadarshina, treating everyone with equal respect. So those are values that I try to live by, and those are, whether they meant it to be like that or not, from Niranjan, from Sri Ram, from Sadhana, from JP, I learned a lot about the values of being a good mediator. And my feeling is that as mediation is really taking off here in India, that we honor our pioneers, those four and others, Justice Cole, Justice Sikri, and so many, Avina, so many, and maintain that sense of purity, that sense of seva, of service, and keep, because, you know, when anything in this world, when it becomes big and successful, that also means there's more challenges. It's just inevitable. So I think this is one of our main challenges, to maintain the purity, maintain our values as we push the mediation forward here in India. Thank you very much.
Thank you. Thank you very much, Mr. Braj Bihari ji, for your valuable presence, your sharing your valuable and motivating thoughts. Ladies and gentlemen, we are privileged and honored to have Honorable Mr. Justice P.S. Narasimha, Judge, Supreme Court of India, in this valedictory session of the National Conference on Mediation. May I now request Honorable Mr. Justice P.S. Narasimha to enlighten us with his vast knowledge and experience on this subject. I invite His Lordship for his special address.
It's a great honor to be following a monk who didn't own a Ferrari perhaps, but has won the hearts of Delhi. My friend Justice Sanjeev Sachdeva, Brij Bihari ji, Sandeep Sharma, Veena ji, honorable judges, and after this conference, I should always be saying, honorable mediators, definitely, because your position has certainly been elevated, and correctly, and for good reasons, which I am going to share with you. We commenced yesterday with the president of the bar telling us how mediation has transformed and the initiatives that Delhi High Court had taken. And Honorable Chief Justice also talking about how he got trained initially by the Delhi mediation, by Samadhan, the learned and Attorney General's two initiatives, the practical approach of my senior colleague Justice Kaul, and a spirited speech by the Honorable Chief Justice, and of course, again giving a complete introduction by Justice Manmohan, my senior in the law faculty. Today's sessions, commencing from the Honorable Chief Justice, whose ideas I'm going to discuss with you. Followed by that, discussion on institutionalization of mediation, and also dealing with the entrenched mindset of lawyers as well as litigants with respect to adversarial litigation, and the clouds over India about that mediation law is going to come. And then we are waiting and we are waiting and we are waiting, and it doesn't rain. And we waited for so long and we stopped working, hoping something good will come. I also have an idea with respect to what to do pending the enactment of the legislation on mediation. By the end of this conference, two things are very well taken. And I'm going to tell you what I don't need to talk about, and therefore confine myself to 2 or 3 small things which I perhaps need to discuss with you. 2 ideas which have now attained the status of principle, as most of us are lawyers, are: number 1, adversarial litigation didn't really work well for us. There seems to be a general acceptance to this idea, and it is now a principle. And I agree, I have no hesitation. Second is that mediation is the only way forward, which is also, I think, is a principle that we can adopt. I don't need to spend much time on this because it's generally the norm now. But 2 things about why adversarial litigation didn't really work for us. First is about the data itself. And it's a less ipsa locuta. The facts speak for themselves. The amount of litigation that we have in our country, unimaginable, and how long it's going to take to complete the existing pendencies. We have just now, the previous panelists have discussed about it. There is yet another reason, which is perhaps jurisprudential, which appealed to me after I took over as a judge. Because as I was as a lawyer in the last 10 to 15 years, the kind of litigation which I was undertaking was more or less a high-end litigation. It's only after I became a judge that I saw such small matters also pending in the Supreme Court. And then people were waiting for about 20-25 years for disposal of such matters. It just doesn't make any sense. One reason, I think this principally it is flawed. Adversarial litigation by itself is based on the truth about a fact. And then the process commences as to what exactly is the fact, the inquiry into the fact. Fact is defined under the Evidence Act is a thing which could be perceived by the senses. So cruelty in a matrimonial matter is a fact. And that fact needs to be proved. So therefore there is evidence of 2 witnesses or 4 witnesses. And then the conclusions to be drawn by the judge on the basis of that evidence is by a principle of adversarial litigation, which makes the first assumption that truth can't be deciphered except by subjecting it to strict scrutiny. How do we do that? We ask 2 competing or contesting perspectives to be placed before the judge. We have the petitioner and the respondents, placing before the judge the perspective that he has about the fact. And all that the judge does is to accept that fact which, according to him, is nearest to the truth. This is the sum and substance of adversarial litigation, where the judge is driven to give a finding with respect to the truth of the fact. As experienced lawyers, and also many of us are judges, it is actually a finality of a decision. Finality of a decision of a judge on the basis of the evidence that is before him which he thinks is most probably the truth. And adversarial litigation gives a stamp to it, saying that that probability which the judge assumes is a finality and matter ends there. This is the process by which, even after independence, we have continued to determine the truth, find the fact, and pass our judgments on cases that are filed before the court. It really didn't work that way. Question is with respect to the truth itself. It's only a conclusion and a finality, but whether it is truth or not, nobody is very clear even after the judgment. Court judgments of the Supreme Court says that Supreme Court's decision is final because of the fact that it's the last court, not because it's true. That, I think, is a difficulty which arose because of the very human nature that you can't find the truth. So therefore, we adopt a theory of this nature and then apply it to disposal of cases and for adjudication purposes. Mediation, on the other hand, doesn't take that line at all. It is not concerned with truth. It is concerned with a little higher principle, which is that you need to live in this world, so therefore you need to reconcile with each other. Whatever may be your stand, whatever may be the truth, as long as you are, as long as my friend has referred to Bhagavad Gita, that there is actually no duality, but assuming that there is a duality between a man and the maker, and as long as the human is subsisting, then definitely he has to have his living and most important feature, that is his recognition. So when you begin to reconcile with each other, which brings out the quality in the human that you are willing to recognize the other person. When you recognize somebody and therefore proceed to reconcile, you are accepting his identity. And if you accept his identity, then you repose in him the dignity. That's all people want. The litigation is loss of dignity, loss of identity, and there's no reconciliation. And they don't talk to each other. We have spoken so much about the reason and causes for failure of adversarial litigation. This is culturally seeped in for us, and this is the norm which I think is at the heart of every religion also. Asian religions particularly propagate this. Sikhism is one of the, Islam talks about it. If you translate into constitutional principle, mediation is in the context of fraternity assuring the dignity of the individual. So therefore you need to live together. So you need to reconcile and not fight with each other. So therefore constitutional vocabulary also is in consonance with the philosophical as well as the spiritual perspective that we can utilize for the purpose of resolving disputes. This much, I think, is enough for what we all accept. There is no debate on the question whether mediation is better or adversarial litigation is better. But now this raises two very important questions. On the one hand, we have adversarial litigation and also the process of mediation. Much of it is covered by adversarial litigation. How do we move forward? Mr. Sriram Panchu has said harmoniously. I use his expression, harmoniously. Then, if it is harmoniously, we have to deal with it in two perspectives. I have a little apprehension also with respect to mediation being referred to constantly in the context of commercial litigation. When I talk about mediation, I'm really concerned about mediation with respect to resolution of disputes in the civil courts. That's where it is needed. And my little fear is that it shouldn't also be, mediation shouldn't also be hijacked or taken away, if it's a harsh word, taken away from those who need it so much in the civil court and utilize it as a medium for commercial litigation. The need for mediation is actually at the lowest courts. And if it has to be harmoniously applied, let us go step by step. One of our panelists said that mediation culture needs to be evolved and applied. Why can't courts ask? If there is no statutory prohibition, courts can ask, why haven't you tried mediation? So this puts the lawyer in a back foot and say, okay, we will try and come if it is possible. So the judge would have applied his mind. A step ahead is a lawyer telling the client, why should I be filing a case? Why can't we work towards a mediation in a matter like this? The third is where the clients themselves are made aware of the fact that this can be mediated through a process. So all this comes by way of some kind of an awareness, which is beginning to take place, undoubtedly. It will happen over a period of time. But one step which we had taken at a time when the draft legislation was made, I had to do a bit of a mediation there also with respect to two perspectives that we got on mediation draft bill. So I took it to Justice Nariman and Justice Kaul at that point of time, that some suggest that there has to be a bar in filing a suit. Another says that it shouldn't be. But my perspective was at that point of time that there shouldn't be. And the reason I'm going to tell you in a short while. Justice Rohington was of the view that nothing doing. They will never mediate. You better force them to do it. So that's how the original clause had a Section 6 as it originally was drafted. That pre-litigation necessarily had to go in for mediation. Only upon failure of mediation, that matters could be heard. And of course, we had another clause which says that as an interim measure. The flip side of it is that nobody really goes in for mediation. Another very difficult part of it is that Chief Justice Sundaresh Menon has very correctly said it. He said, if you don't develop the infrastructure for mediation and you go ahead and prescribe such mandatory provisions, then they're not going to work. Section 6 will be a farcical. You will have like a curative petitions that we get in the Supreme Court. So you have somebody to give a certification that we have tried, but it didn't work. And immediately somebody can go and file an application for interim measures. There are a large number of statutes that we have, labor statutes, other statutes, where provisions are there with respect to the remedies that are to be provided, but no infrastructure, no machinery provisions for implementation. So it will be yet another provision which will be farcical in nature. So that's one big question that we need to answer. What pandemic has done to us is a technology which was always available to us, that VC technology, but we were forced to use VC because of the pandemic, and now we have all got used to it. That's one advantage of forcing somebody to get adapted to a method or a procedure. That is another aspect of it which we could consider when perhaps the government takes a decision of making it mandatory. So, the 2 points which I wanted to discuss today is if mediation provision section 6 comes into force, or it takes time for the mediation culture to develop, then how do we proceed? According to me, the biggest stakeholder first will be the lawyer, second will be the litigant. Many might not agree with me. The reason is that to make mediation successful, it is very much necessary to engage with the lawyers. I'm saying it from the perspective of the lower courts, where clients repose a lot of trust in lawyers. They completely believe in him. You're not taking exception cases where somebody hits somebody. With the trust that they have in the advocate, and the advocate is now asked to get into mediation, the steps that we need to take is what I'm going to talk to you. First and foremostly, it is the training that the lawyer must get. So much of unlearning is necessary. Second most important thing is about the revenue model. These two, if we don't invest much, mediation will become extremely difficult to get entrenched into the districts and become a part of the judicial administration process, in which advocate is also an integral part. These are not difficult things to do. Training for an advocate, I think, can easily be undertaken. Training for for the judge is anyway being done through judicial. We have various other processes by which judges get trained, but advocates can be trained. The process of unlearning is very much necessary. I recall as I was appointed as an amicus in BCCI case. So one day Justice Bobde said, it might take very long, but you go ahead, you be a mediator in the matter. So I was stunned because there was a conflict of interest. And being an amicus in a matter, in which way can I go and mediate? So he had no interest in hearing my submission. He said, go ahead. And it was just before the summer vacation or somewhere after that, I couldn't. So with that kind of a mindset, I just called some of those BCCI, the state cricket associations. I had read up the matter for days on and drawn my conclusions. And when they came, I told them that, listen, this is the problem you have. This is the way you can solve it. So all of them heard me and for a little while. And last of the persons, I think somewhere from Saurashtra, he said, "Aap bhi nahi sunte hain." I was a little stunned. So I said, all right, let's do this. Then I said, I will listen to them. It is there on BCCI website. 100 hours I heard them. 118 hours. I just didn't talk. One after another came, spoke to me. There was a committee of administrators appointed by the Supreme Court. Already by that time, about 5 judgments had come of the Supreme Court. So each one said whatever he wanted to. I just listened. And it was so difficult initially. You know, lawyers are not used to keeping quiet at all. And you think you know the answer. I said, what's he saying? Even this is a clause in that BCCI. The rule says very clearly that. So he spoke and spoke and spoke. And that is one thing. After that, they were substantially satisfied. The second experience was when I called for when I met the other side, the COA members. I spent some time with them, and the second meeting, I had a joint meeting in which the other members of the cricket associations were so very hesitant to talk. And even before they said, the COA members would put them down. I said, no, what's this? This is not the way. So I had to tell them that this is not the way. I am the mediator. And that equality of status that they realized that they would get before a mediator is yet another aspect I thought is repose confidence in them. That you are equals. I mean, you've come to reconcile your differences. So therefore, there can't be a mediator who is partisan or who is rather afraid, who is more respectful to one and less respectful to the other. I didn't do anything. I did nothing. I just listened to both of them. And I said, this is all that they want. What's the difficulty? And each one after another, they sat together, and finally elections were conducted, and matter got reconciled to a very, very large extent, except what some normative principles which has to be. That is my very small experience about this process of unlearning is very much necessary for lawyers. Now, what would happen tomorrow? I agree with Justice Butt saying that it's not a monopoly for lawyers. Mediators, definitely not. I mean, even the draft bill doesn't say that lawyers should be. There are certain conditions, there are certain norms by which a mediator is required to comply with. But today, if assuming there is a pre-litigation prohibition, first to go to mediation, all over the country you will have a situation where we need immediately the whole establishment of mediators. This will lead to definitely lawyers doubling up as mediators. And for some time at least, we are going to have trained lawyers as mediators. Of course, non-lawyers will also be there. So therefore, we'll have lawyers who are mediators, we will have lawyers who are litigants. And they would be interchanging their roles. I think this process will continue for some time till the process of specialization will set in, or lawyers will decide either to continue as litigants or to specialize in mediation itself. That will be the advent of new era, which is going to be much better for us, as specialization is creeping in on subjects even within litigation. That is one positive thing which is going to happen. In the meanwhile, a necessary thing which needs to be done is the market operation, where mediation service providers as well as mediation institutions must come up. We are all in this context waiting for the bill to come. My view is that I don't think we should wait anymore. It's not the statutes which have made world of difference, as Justice Butt was also saying with respect to very many things about the educational institution, introduction of technology. Things will happen. It's the real engines are those who take up the task and then take it ahead. As we open up more and we see opening up of more and more mediation institutions or mediation service providers, this will lead to more number of lawyers getting enrolled and getting certification. And I think MCPC can have a bigger role, which I was just discussing with Justice Kaul, that pending mediation, that initiative can be taken, and that infrastructure can actually be created. And if a legislation comes, it will be anyway in place. I mean, things are not going to be contrary to anything else. So this process, I think MCPC will take the initiative right away and commence and encourage the institutions, encourage as well as the service providers and also to encourage the court-annexed mediation centers and ensure that the processes takes place. Lastly, this thing is a little troubling about revenue model for a lawyer. There is this suspicion that if a client engages me as a lawyer and I am not a trained mediator, then I go and engage yet another mediator. As of now, mediators take nothing. And I don't believe that that should continue for long. It must be professional. Professionalism must get into mediation. And we must have world-class mediators. We already have few, but then that should become a norm over a period of time. And we will have in the law colleges where perhaps in a post-graduation one would specialize in mediation in India. That hasn't started yet. That is one other suggestion I had given to as a chancellor in the Goa University, that you must have an LLM for mediation with a practical training so that somebody can start as a mediator himself. So these are the processes which need to be undertaken. And my endeavor was to highlight these two needs of the day. Rest of it, you are all mediators, honorable mediators. So therefore, there is no need for me to tell you. I am sure that things are going to change. And as the president of the bar was saying, that lawyers have taken to mediation very easily. Delhi is not the benchmark. Mohit, places are different. I mean, in the district, as we see, things are very different. And this must be replicated there, for which the chief justices of every high court must take that additional step and ensure that this is a beautiful thing that Justice Sanghi has collaborated with the Delhi Mediation Center. This kind of a thing must be done elsewhere, and ensure that the capacity building is done, and the lawyers also participate more and more in mediation in the districts. I am very much interested in this project, and I intend to dedicate myself in ensuring that whatever it needs to be done for mediation to be brought, I want to give my time, my effort to this. I am in a bit of a self-congratulatory mode because the little interaction I had, Manmohan was kind to refer to whatever little suggestion I had made, but then all this is their effort. It's an excellent conference. It's there for everybody to see. And Veena was there to discuss. Sanjeev was also there. So I enjoyed participating in every part of it. From the time I got a call from my dear friend, Manmohan, till I'm going to end now. Thank you very much. Thanks a lot.
Thank you very much, sir. We are grateful to Honorable Mr. Justice P.S. Narasimha for guiding us by sharing his valuable thoughts and experiences on this subject. Ladies and gentlemen, in this 2 days National Conference on Mediation, we had 4 technical sessions in addition of opening and closing ceremony. We are now at the concluding stage of this conference. And at this moment, I invite Honorable Mr. Justice Sanjeev Sachdeva, Judge, Delhi High Court and Member Overseeing Committee, Samadhan, for his concluding remarks. Honorable Mr. Justice Sanjeev Sachdeva.
Justice P.S. Narasimha, Judge Supreme Court of India, Mr. Braja Behari, Senior Mediator and Trainer, Mr. Sandeep Sharma, Secretary, Delhi High Court Bar Association, and Ms. Veena Rally, the Organizing Secretary, and really the backbone of this conference today. It becomes a very difficult task coming in after such distinguished speakers. I'd like to begin by expressing my gratitude to all those who participated in the national conference organized by Samadhan in collaboration with NALSA and the Mediation and Conciliation Project Committee over these 2 days. All of you took out time to share your short thoughts and ideas with us and contributed to its success and our esteemed audience. Our keynote speakers, Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Executive Chairman NALSA and Chairman MCPC. Our special guests and panelists, Chief Justice Sundaresh Menon, Chief Justice of Singapore, Justice Sanjeev Khanna, Justice S. Ravindra Bhatt, Justice M.M. Sundaresh, Justice P.S. Narasimha, Judges Supreme Court of India, Shri Venkatramani, Attorney General for India, Justice N. Koteshwar Singh, Chief Justice Jammu and Kashmir and Ladakh, Chief Justice Satish Chandra Sharma, Chief Justice Delhi High Court and Patron-in-Chief of Samadhan, Justice A.K. Sikri, Justice Manmohan, Justice Chawla, Dr. Sudhir Jain, Mr. Sriram Panchu, Mr. Braja Bihari, S. Sushila and Anil Xavier. We are thankful to all of you for having enlightened us. Now, at this juncture, I realized after all these esteemed speakers that I have the unique privilege of having been exposed to mediation in different facets. First, as a lawyer appearing in mediation proceedings, then as a trained mediator, then as a judge on the bench, and now I'm heading a bench which deals with these disputes every day. I'm heading actually the family bench, the family court appeals. So I'm exposed to mediation in all facets, which I found was the unique privilege in the entire speakers today. So the training, which I would say as a mediator, not only changes your knowledge base, but also makes you a better human being. As Justice Kaul said in his speech, that conflict is part of life and there can be no society without a conflict. We judges are also human beings living in this society which is replete with conflicts. Conflicts could be of serious nature or could be mere differences of opinion. We as individuals come across several conflicts and differences of opinion in our daily life. The difference of opinion could be as short or as small as where does the family go for dinner tonight or where do we go on a holiday. The training as mediator enables you to tackle each difference of opinion with ease. It enables you to think out of the box and separate the person from the problem, thereby enabling you to look at the viewpoint of the other side. It thus prevents a mere difference of opinion into mushrooming into a full-fledged conflict. And we see that as family court judges or appellate court judges for family courts, that these are small differences which have mushroomed into big conflicts. And the best part of Indians, as we all are Indians, is that we like to jump into every dispute. The moment you see a dispute happening on the street side, we will jump into it because we have the solution for everything. Any dispute and we are ready with our opinion. But that is not the role of a mediator. Mediator does not give solution. He acts only as a guide. Mediator will assist the parties into thinking of various solutions and then guiding them to a solution that is correct in law. It's like guiding a child learning to walk. When the child takes the first step is learning to walk, the parent does not tell the child where to go. The parent lets the child decide where to go and then just watches over the child take the steps and supports wherever it is needed. That's exactly how the mediator will deal with the dispute. The mediator will not provide a solution. The best part of a mediator is he coaxes the parties into thinking of a solution. And when they come up with a solution, they think that this is our solution. And if they've accepted it, then there's no reason to go against it. It's not a decision which is thrust upon them. It is a decision that they have come up with. It's a solution that they have come up with. The role of a mediator, as Justice Kaul said, is to uphold the rule of law. A mediated settlement is the solution brought about by the parties themselves. And they understand that they have to live with the solution and move forward with it. As referral judges, we have to ensure that parties are prepared and made ready to mediate their disputes before they are referred. Sometimes the parties are reluctant to accept mediation based on their earlier experiences. But we have to also ensure that reference to mediation is not a guise merely to protract litigation. We have to also monitor the dispute. In case that the dispute is not settled and it comes back, there is still some scope for the judges to intervene and bring about a settlement. Your training as a mediator would go a long way in understanding the core dispute and bringing about a settlement. The skills that you acquire as a mediator go a long way in resolution of disputes. mediated settlement is not just ending one dispute. It brings to end the primary and the secondary disputes between the parties and also the potential appeals and several tiers of litigation. Now, we don't refer matters to mediation for the asking. We first confer with the parties, make an attempt to mediate. There are two benefits. Some of the disputes get settled at that stage and they are not even required to be referred to mediation. Secondly, when the parties go to mediation, they are prepared for some form of a settlement. Sometimes what happens is you find that parties are on completely different planes. For example, in a matrimonial dispute between husband and wife, for one, if the only solution is the divorce, and for the other, divorce is not an option under any circumstance, there's no purpose in referring the matter to mediation at that stage. Maybe sometimes down the line they may change their mind and they may want to go ahead. I remember a custody battle, and sometimes what happens is when you are in courts and these matters come up, the mediator in you always likes to come out. So the custody battle between a wife and with regard to a young boy, the mother had got an assignment to go for a professional education for 2 years to Germany and then work for 2 years there. The child had also got admission in the school, but the father was very reluctant. He was not agreeing to let go. His only ground was that my access to the child would be deprived for that 4 years. You see, VC access is there, but it's not as good as a physical access. We interacted with the parties over 2-3 sessions. Ultimately, the matter got settled. The husband consented for the wife to travel to Germany with the child. And in fact, that was not all. He also agreed to shift his base to Germany. They both had originally lived in Germany when they got married. He also agreed to shift his base to Germany because he was working from home with a foreign firm. And not only that, they even agreed to live together in Germany as a family. So that was a settlement we could bring about. Again, this was the mediator in you that permits you to do that. I also remember one dispute between a Sardar family. There were two elderly Sardar gentlemen in their 60s who had come in a court for some disputes. There was a property dispute. So I looked at them and then suddenly the mediator in me woke up. And I asked them, and this is what the mediation training tells you, that separate the person from the problem. So I asked them, I said, when you were young, your father would take you to a Gurdwara. Which Gurdwara was that? So they pointed out to a Gurdwara. I said, it was about 12 in the afternoon. I said, do one thing. Just go to that Gurdwara again. Don't talk about this dispute. Just go there. Spend some time there and come back. They came back in the afternoon and the dispute had been settled by that time. Because they could relate to the old times. So as a mediator, you are trained to make the parties think about the good times they've had together and look forward. Now, mediation training never goes waste. Mediation training is multidisciplinary, borrowing from the fields of psychology, sociology, economics, neuroscience. These conflict management skills include, as Justice Narasimha said, listening, communicating, searching for prevention-based solutions, exploring common ground and establishing trust. Justice Kaul also pointed out in the morning that sometimes letting the parties have their say makes a lot of difference in their feeling of justice. Efforts to resolve disputes through mediation never go waste. Even if they are not successful once, they can always be successful at a later point of time. So one should never give up. Now this conference gives us some takebacks. We require a collaborative effort from all stakeholders. We need to create a framework for regulation of mediation. There is need to build professional capacity. The moment the bill comes up, that becomes an act, there will be need for mediators. So let us start building towards that. Let's start training people. But we have to remember that we have to have consistent standards and apply quality check for mediators. Now they will require repeated training, because once you've trained for 40 hours, going into mediation, slowly you start forgetting your mediation training. You need to have constant refreshers. it may be a good idea to work with the stakeholders to develop a deep understanding of mediation, how it can help the client resolve their disputes. It is important to lay emphasis on mediation advocacy, and there is a strong need to hold programs and trainings around that. As Honorable the Chief Justice of India said, mediation, when done well, can truly help felicitate justice for all. Thank you very much.
We are grateful to Honorable Mr. Justice Sanjeev Sachdeva for his concluding remarks. Ladies and gentlemen, to make this national conference a great success, the Team Samadhan has been working tirelessly day and night for the past months without any break. At a time when we are going to conclude this national conference, it's time to express gratitude to one and all who have made this event memorable. For this, I invite the organizing secretary of Samadhan, Ms. Veena Raliji, for proposing the vote of thanks to all of you. Veena ji, please.
Honorable Justice Narasimha, Honorable Justice Sachdeva, Mr. Praja Bihari, Mr. Sandeep Sharma on the dais, all the honorable judges, all the honorable chief justices from various states, various areas, and all the honorable judges from our Delhi High Court, all the judges from district courts, Mr. Mohit Mathur, our president, Mr. Chetan Sharma, Additional Solicitor General, all the esteemed panelists, senior advocates, and all the members of Samadhan family, along with all the mediators from various centers. Honorable mediator, sir, I'll say at the end because now you have given us a designation. Representative from various mediation centers, the family of mediators from all over the country, and of course now I will say honorable mediators. I'm sure this national conference has created a synergy and collaboration among all the stakeholders of mediation in very special way that we don't see often. It has been a celebration of the exchange of ideas, a forum for shared experiences, a festival of faith, peace, and harmony. We have truly celebrated the dawn of the golden age of mediation. It has been a greatly humbling experience because there is so much to learn from so many of us in so many ways in our journey of mediation. We hope Samadhan has sown the seed for the revival of a national movement of mediation before the advent of the new Mediation Act. We believe this synergy will be necessary both to examine and implement the new act. We also believe this synergy is a reflection of our common commitment to empower parties to find closer to their conflicts, a reflection of the philosophy of mediation and a reflection of our belief in the power of the human spirit. Firstly, I convey my heartfelt thanks to the Chief Justice of India, Dr. D.Y. Chandrachud, for being with us yesterday for the inaugural of this national conference and with a powerful message to the public at large: mediate, don't litigate, and for sharing his valuable thoughts and vision for the future of mediation. I also thank him for releasing mobile app and our book, Mediation and Its Promise, and for his messages both in the book as well as in the short film of Samadhan we tried to put together for this occasion. I thank Chief Justice of Singapore, Justice Sundaresh Menon, for honoring us by especially traveling to Delhi to be with us today and for his erudite plenary session on mediation at the dawn of a golden age. I also thank Justice Menon for allowing us the liberty of borrowing his topic, actually it was his topic, and making it the theme of the conference, as suggested by Justice Narasimha. His message of collaboration between adjudication, arbitration, and mediation, if adopted in real sense, will surely go a long way. On behalf of the Samadhan family, I wish to thank our mentor, our guide, and our pillar of strength, Justice Kaul, who has held our hands at every stage of our mediation journey, first as a member of Samadhan's family, overseeing committee member, then as its chairman, and now as chairman of both NALSA and MCPC. Both NALSA and MCPC giving us unstinting support, I really quote and unquote, unstinting support from them, without which this conference would not have been possible. We are grateful for his vision and perspective in holding this conference, for converting the conventional mechanism of dispute resolution to non-confrontation. I thank Justice Kaul from the bottom of my heart. I thank the learned Attorney General for his candid views yesterday at the inaugural, and especially for his two announcements, the third one, for which we shall remain curious till we get it. From the kind of support he has given us right from his appointment as the Attorney General, we now believe he is a part of Samadhan and we have a first right over him. I thank all the Supreme Court judges, and especially Justice Bhatt, Justice Sanjeev Khanna, Justice M.M. Sundaresh, for sharing their valuable ideas as panelists, and especially Justice Narasimha for his minute-to-minute guidance from the beginning till the end of this conference, for his invaluable views on the planning of the book and for the valedictory address. I think a round of applause is required, I think. I profusely thank our Chief Justice, Shri Satish Chandra Sharma, Patron-in-Chief, for his continuous support to Samadhan and his incredible message to promote institutional culture for developing confidence in parties. I would like to extend my heartfelt gratitude to our esteemed guests, Honorable Chief Justices from all the High Courts, Honorable the Chief Justice of our court, all the Honorable Judges of all other High Courts, Honorable Judges of our court, our esteemed panelist, Mr. Braja Bihari, who has traveled all the way from US, Mr. Shriram Panchu, Mr. Anil Xavier, and Ms. Sushila, who have traveled across India to share their insights with us and to guide us even today as their trainers. I convey my heartfelt thanks to Justice Manmohan and all the members of the Overseeing Committee, all the members of the Coordination Committee, for their untiring efforts to see what you have experienced since yesterday. A very special thanks in this process to two dynamic officers, Ms. Santosh Snehiman, Member Secretary NALSA, and Ms. Meziolu, Member Secretary MCPC, for their incredible support to us from the day of conception of this conference till today. I'm sure I will continue to have this support for further follow-ups of this conference and more such future events. I thank Justice Sachdeva for his continuous support to Samadhan, for his encouragement to all of us to familiarize us with technology during COVID-19, and now getting the new mobile app. I think it's applaudable. Mr. Mohit Mathur, President of Delhi High Court Bar Association, and his enormous support to Samadhan, along with Mr. Jatan Singh, Vice President, Sandeep Ji, and of course, all the executive members. I thank the publication committee, particularly my dear friends Sadhna Ramachandran and Sudhanshu Batra, for achieving the impossible in requesting authors and editors for the book Mediation and its promise. They have actually promised to us to get this book on this day, and they kept this promise. So this is the first promise of the mediation. In record time we have got this book. And I also thank Mr. Vinay Jain for his invaluable contribution in designing the book, publishing it in the shortest possible time. I thank our young team of illustrators who go by the name Spinetail. You must have seen the caricatures in the book, also in record time. I also thank Parul and Yogesh of FESFO Communication for preparing film on Samadhan despite tremendous time constraints. They prepared it in 1 week, and they rather gave us the final film on the day itself in the morning at around 7 a.m. I'm thankful to Mr. Janendra Mishra for his anchoring. I think it added flavor to this conference. I wish to record my deepest sense of appreciation of the Registrar General of our High Court, along with Mr. Kamaljeet ji, Registrar Vigilance of our High Court, and for the whole team. I'm not naming because the list is going to be very long. With Davinder ji, Neeraj, Sunita, Veena ji, and each and every person, starting from protocol to see that everybody is comfortable in this conference, for their enormous efforts in seeing this event implemented. And now, my deep sense of thanks and appreciation goes to all the participants who are here, who have attended and participated in this conference. And at the end, I request you all to show our gratitude by a wide round of applause to thank each one who has ensured the success of this conference. I just want to convey one thing, that Justice Manmohan has put lot of efforts in this event, spending his morning hours during morning walk. I could see sometimes it's his breathless voice coming to me. At 1:15 come to my chamber, at 2:15 sending some officers from his chamber to our side. And I think most of the committee members will endorse and will agree with me. It's endless. I can't express my gratitude, sir, in words. Otherwise, this conference would not have been possible. And this was his idea, initiated, as he said, even at his initial address, when he spoke with Justice Kaul and got this happening today. My enormous thanks, sir, to you for this conference. I'll just say, जब हम लोगों ने मीडिएशन शुरू की थी, तो एक छोटे छोटे कमरों से शुरू की थी, और आज हम देख रहे हैं कि हमारा परिवार कितना बड़ा होता जा रहा है. I would like to say, though it's a very usually heard couplet, but यहाँ मुझे लगता है कि वो बहुत उचित है, इसलिए मैं कहना चाहूँगी. मैं अकेला ही चला था जानिबे मंजिल मगर, मैं अकेला ही चला था जानिबे मंजिल मगर, लोग साथ आते गए और कारवां बनता गया. एंड आई एम श्योर ये कारवां और बनता जाएगा अगर हमें जस्टिस मनमोहन, जस्टिस कौल, जस्टिस नरसिम्हा जैसे जजेस मिलेंगे, और हम और ऐसे इवेंट्स करके अपने प्रोग्राम को और अच्छा बनाते रहेंगे और आगे मिलते जुलते रहेंगे. विद दिस आई थैंक यू एवरीवन फॉर बीइंग हियर एंड सपोर्टिंग अस.
Thank you, Veena ji, and thank you very much to all of you, ladies and gentlemen. Wishing the best for all of you. Ladies and gentlemen, now we conclude this 2 days national conference on mediation. I will request our technical team to get ready for the national anthem. And just after getting the signal from them, I will request all of you to rise for the national anthem. But before that, we wish all the best to all the efforts which has been made during this and thoughts being shared during this national conference. This was, as you feel, a great initiative and first of its kind in the history of mediation that one such kind of national conference was held. So, ladies and gentlemen, are you ready? Please, technical team. Sir, they have to get ready for that, the technical team. Okay, that's fine. So, let's rise for the national anthem and we can sing ourselves the national anthem, Rashtragan.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
थैंक यू वेरी मच. बहुत बहुत आभार हृदय से आप सभी का, देवियों सज्जनों, लेडीज एंड जेंटलमैन. और आभार उन सब का जिन्होंने जिस रूप में भी कंट्रीब्यूट किया. मैं आप सभी को इनवाइट करना चाहूँगा हाई टी के लिए. लेकिन एक रिक्वेस्ट भी है, क्योंकि पहले जो फ्रंट रोज और डायस पर डिग्निटीज बैठे हैं, first they will take the exit for the venue where they will be served high tea, and after that later on all the students and other persons, other guests, they will follow and proceed to the dining area where high tea will be served. So thank you very much. बहुत बहुत आभार आप सभी का और बहुत सारी मंगल कामनाएं, गुड विशेस आप सभी के लिए, देवियों सज्जनों.